Article 1343. Misrepresentation made in good faith is not fraudulent but may constitute error. Under Article 1343, it states that the misrepresentation must not be on purpose and it will be made in good faith. However, it may be considered as a mere error. For example, Belinda sold Kai a diamond necklace which she had expected a true diamond necklace, but it turned out that it was not. So in that case, if Belinda did not know that the necklace she's selling is not made of a real diamond, then it is not her purpose to do. The misrepresentation in this situation is not fraudulent, but it may have an error or mistakes. Besides, Belinda will be required to return Kai's payment. Therefore, recall the rule. The misrepresentation that made in good faith is not fraudulent but may constitute error. So, the next one is Article 1344. In order that fraud may make a contract voidable, it should be serious and should not have been employed by both contracting parties. Incidental fraud only obliges the person employing it to pay damages. So, let's first define fraud. Fraud is referred to as fraudulent purpose, manipulation, or misrepresentation that will lead to an ordinarily prudent person leading into an error. This article states that the fraud may make a contract voidable when it must be serious and it should not be done by both contracting parties. Parte delicto is a Latin word for unequal fault, meaning two or more people are guilty for a crime. Moreover, there are two kinds of fraud, dolo cosante and dolo incidente. So, dolo cosante, or also known as casual fraud, this is referred to as misrepresentation that used by one party for the purpose of securing the consent of the other party to enter into the contract. And the remedy for this is the annulment of the contract. On the other hand, dolo incidente are called incidental fraud. This is a misrepresentation that is not serious and without which the opposite of the party would have still entered into the contract. So, the remedy for this is to pay the damages. In addition, to prove the existence of the fraud of the proof should be clear and convincing evidence to meet the required burden of proof. So, next is Article 1345. Simulation of a contract may be absolute or relative. The former takes place when the parties do not intend to be bound at all. The latter when the parties conceal their true argument. Under Article 1345, it states that a simulation of a contract is a mutual agreement of parties but does not intend to express the real intentions of parties. To further understand it, there are two kinds of simulation. Absolute simulation refer to the parties when it takes place and does not intend to be bound at all. In short, they have not intended to enter into a contract. On the other hand, relative simulation is when the parties conceal true agreement. In this, they have the intention to enter into a contract. However, does not express the real agreement. To further comprehend absolute and relative simulation, let's proceed to Article 1346. So, Article 1346 is an absolute simulated or fictitious contract is void. A relative simulation when it does not prejudice a third person and is not intended for any purpose contrary to law, morals, good customs, and public order or public policy, binds the parties to their real agreement. This article states that the fictitious contract is void because both parties are not intended to enter into a contract. The parties only pretend that they have a contract so that they can deceive others. A relative simulation, when it does not affect the rights of the other about people and the cause is not against the law, morality and good manners, public order, and public policy, binds the parties to the real agreement. In other words, in absolute simulation, the contract does not exist. In relative, there is a contract. However, both parties do not show the true intention why they have entered into a contract. Moreover, as a result, an absolute simulated or fictitious contract is may it recover from each other they have they have given under the contract. For example, Kim and Shanna executed a contract of sale to deceive others without any intention to enter into a contract or any legal relation, like property. But the deed of sale is just a paper to deceive other people and without any intention to enter into the contract. So the explanation to this is the contract will be void because Kim did not actually sell the property to Shanna. So that was of sale. That she will prevent having a legal effect. In this situation, there was an existing contract. However, the party does not show the real intention of it. Additionally, in this article, there are two juridical acts involved in simulations: ostensible act and hidden act. Ostensible act is the apparent but fictitious contract executed by the parties, and it is always void. And the second one is the hidden act. It is the real agreement contemplated by the parties that will be valid if it is not contrary to law, morals, good and customs, etc.
Article 1350. In onerous contracts, the cost is understood to be, for each contracting party, the prestation or promise of a thing or service by the other. In remunerative ones, the service or benefit which is remunerative, and in contracts of pure beneficence, the mere regularity of the benefactor. Remunerative contracts. It is a one-party where give something to other because of some service or benefit given or rendered by a latter to the former. Gratuitous contracts. These are the essentially agreements to give donations, generosity, or liberality at the cost of such a contract. Manual process as a cost. A promise made by one party following the forms required by law may be a good cause or consideration. Accessory contracts. These are the performance of other contracts that has been secured by other person either by acting as a surety on a bond or giving his property by the way of mortgage to secure the other person's contract. Article 1351. The particular motives of the parties is entering into a contract are different from the cause thereof. Cause and motive distinguish. A cause is an important reason for the contract that should be distinguished from a motive, and which is the particular reason for the contracting party to does not affect the opposite party. Motive and causes differences. The cause of the contract is the objective and juridical reason for the establishment of a contract and is always the same, while motive is the psychological or personal purpose of the party in getting the object and differs with each person. Each party may have its own personal reasons or motive in entering into a contract. Motive or even in an illegal motives does not affect the validity of the contract. Exception. If the motive predetermines the purpose of the contract, motive has been regarded as cause. For example, Tao Tao sells her house and lot to Chen for 1 million pesos. In that example, for Tao Tao, the cost of consideration is the 1 million pesos, and her motive is to use the 1 million cash in business for another house. On the other hand, in this situation, Tao Tao's motives in selling her property is to defraud Jenny, a creditor, so that Jenny may request the rescission of the sale.
Article 1352 to 1353. Contracts without cause or with unlawful cause produce no effect whatever. The cause is unlawful if it is contrary to the law, morals, good custom, public order, or public policy. So, Article 1352, we all know naman na if there is no cause, mabuvoid ang contract because they are lack on essential element and they are not only voidable but void and it produce no effect. So, Article 1352, we have requisite of cause. It must be present. Of course, it's very essential that the cause is present kasi kapag walang cause, kulang yung essential requisite ng contract which is consent, object, and cause. Second, it must be true. Last, it must be lawful. So, ano bang meaning nito? It means it's not contrary to the law, morals, good custom, public order, or the public policy. So, sa Article 1352, may tinatawag din tayong effect of absence of cause. Absent of or want of cause means that there is a total lack of any valid consideration for the contract. And also, the effect of eligibility of cause. Eligibility of cause implies that there is a cause that the same is unlawful or illegal. So, next is Article 1353. The statement of a full cause in cause contract shall render them void if it should not be proved that they were founded upon another cause which is true and unlawful. So, dito sa article na to, in this provision, it talks about yung mga effects kung ang cause ay false or hindi totoo. So, valid yung cause pero hindi siya yung totoong cause, it means mabuvoid ang contract. Pag hindi na prove ng parties na it is founded upon another cause which is true and unlawful, and if the parties naman can show na they are really another cause, then that cause is true and lawful, the parties should be bound by the truth agreement kasi meron naman talagang tinatawag nating cause. Pero if di nila ito na-prove dahil founded na may full cause, then the contract is void. So, bigay tayo ng example for Article 1353. No? So, for example, nag-appear sa contract ni A and B that the former A sold to B a motorcycle for 30,000 pesos. Pero yung totoo, wala pala talagang payment na nangyari between A and B. So, ang reason is that the sale was made merely to defraud A's creditor. So, can be seen that there is a statement of a cause, but the same is false o hindi totoo. Supposingly, however, that while it is true that no payment was made by B to A, but B never the sales had rendered service for A, equivalent to 30,000 pesos, for which reason A parted with his motorcycle. So, although yung cause stated na false nga o hindi totoo, there is another cause proved which is true and lawful. So, the contract is valid.
Article 1354. Although the cause is not stated in the contract, it is presumed that it exists and that is lawful, unless the debtor proves the contrary. Under Article 1354, it states that in the contract, thus the cause must be presumed to exist, and the reason is lawful. This presumption is related because it is presumed by law that all contracts have corresponding cause that is lawful. However, since it is just a presumption, it can still prove otherwise. Upon a burden of proof, it is necessary to present evidence to meet prima facie case or legal presumptions, in which, if the proof to the contrary is not presented, it will prevail. Moreover, if the cause is not stated in the contract, it will be believed to exist, and that is lawful. In short, it is not necessary that the cause is explicitly stated in the contract, as long as it is presumed to exist and lawful. For example, in promissory note, 1 month after the date I promised to pay or order Shana the amount of 50,000 pesos, signed by Kim. If you look at the promissory note above, you will notice that it does not state that Kimberly promised to pay because Shana did not receive anything worth 50,000 from Kimberly. In that, the promissory note will still valid when the cause is not stated in the contract. As long the law presumes that even the cause is not stated in the contract, it must exist and the reason is lawful. Next, Article 1355. Article 1355. Except in cases specified by law, lesion, or inadequacy of cause shall not invalidate a contract unless there has been fraud, mistake, or undue influence. Under Article 1355, it states that a lesion is any damage caused by the fact the price is inadequate for a thing sold. However, a lesion does not invalidate a contract unless it is specified by law, and when it resulted from fraud, mistake, or undue influence. It is the time the lesion became a good ground for invalidating a contract. For example, Shanna sold her 5 million worth hacienda house to him for only half of a million pesos. In that example, you will analyze that Shanna sold her hacienda house for only half of a million to him. That's supposedly worth 5 million pesos. The price is cheap compared to the real worth. In that case, there is inadequacy in terms of price. But the contract of sale remains valid unless there is proof that has been a mistake, it was done by fraud or undue influence. If the if the exemption is present, the contract of sale can be annulled by court, and lesion can be evidence for the presence of mistake, fraud, or undue influence. Therefore, always remember the golden rule of this article: lesion does not invalidate a contract. That's all for our reporting. Thank you for listening. Have a good day.